the Don Lamont Hall.
This is the only hall I know.
Right. So, yeah, okay, listen, well said. So, I'll see you later.
Okay, I'm just going to grab the
Right,
Good luck.
okay, good.
They weren't given question sheets, were they? We were just asking them to shoot up pieces of paper?
Yeah.
Yeah.
Okay.
Any idea?
Let's see. I can check and see, and if it's not in there, I may not have received it.
He's not here yet.
He's not here yet.
When he gets here, do you want to
Cameras for
grab him and
those things,
scribble
I think.
some things down? Because we have time.
Usually
Yep.
the ones
Oh,
at
yeah.
the Air Canada Center
And
that follow
well,
the plane
anybody
around.
else's?
Those
No,
things.
it's ask Randy. He might be missing somebody.
Okay, so Pitblado.
Up there, I think.
I was down in Australia recently and I was giving a speech. It was a huge theater and they had huge screens like that on either side. It was gigantic. I can make it up.
Jack Siegel, I think. Well, Marty Doane?
Hey, how are you? You're looking a little relaxed compared to normal.
You got a new haircut, I see.
Yes.
Looking very young. Nobody's gonna take you seriously, you know.
I know it's true. My wife says I look like the.
What was his name? Rudy Hauser.
Yeah, that's right. Doogie Howser of the law profession.
So everybody's running late today, I take it.
It looks like it. Yeah, the weather.
And after I take TTC to come up, you know how expensive it was for me.
Thank you. We have to deal with. Thanks.
Yeah, I think oh, that must have been another second. It must have been in regards to one of your other questions. I'll give it to you.
Okay.
Just call Mark.
Okay. From.
Good morning, everyone. There are a number of people who aren't here yet, but we are going to start because we have a very full morning. My name is Helen Bernstein. I'm a Council Program Development of the Law Society. I'm very pleased to welcome you to today's program, our 6th annual 6-Minute Employment Lawyer. We hope you take some time at the end of the program to fill in the Great Course Evaluation form. We just want to mention that this program is being videotaped. Finally, we want to thank our 2 chairs, Matt Certosimo, a partner in the Labor and Employment Law Group of Borden Ladner Gervais, and Randy Echlin. No need to go through his bio today, except to say he's soon to be the Honorable Mr. Justice Echlin of the Superior Court of Justice. I'd also like to thank all the members. We also want to thank all the members of the faculty today for all their efforts in making the program come together. I know you're in for a very interesting morning. I'm pleased to turn the podium over to Randy.
Thank you, Helen. A couple of administrative matters. At the end of the program this morning, we have the panel, and feel free to shoot up questions during the morning or during the break to us, and we'll try to get them to the panelists. Secondly, because we have such a high repeat record of people who have been to previous 6-Minute Lawyers, you'll know about the magic lemon and how we gong people with the bell, and the speakers will keep themselves to their times. I'm privileged to introduce the Associate Chief Justice. We're very lucky to have him with us today. Dennis is truly a Renaissance man. I mean, if you read his resume, it's very, very modest, 3 or 4 lines in the material. But I can tell you he's not only a former criminal lawyer, but a Yukon magistrate, a law professor, a top-notch litigator, an inquiry head, and now as Associate Chief Justice of the Court of Appeal, Canada's Dream Team. He's at the peak of his of the judiciary. But when I think of Dennis, I think of one word. That's H2O, water. And it's not just because of Walkerton. Those who golf with him know that Dennis has an affinity towards water. And when Dennis left our firm a few years ago to go to the bench, we made a presentation to him. It was a canoe. He's an avid outdoorsman. Ladies and gentlemen, our Associate Chief Justice, Dennis O'Connor.
Well, thanks, Randy. And just before I begin, mention was made of the fact of Randy's recent appointment. I know those of you who've been coming here for a number of years, know Randy's contribution in organizing this. He's got a splendid appointment to the Superior Court. On behalf of the bench, I can formally say we're absolutely delighted to have him coming to join the troops, and I formally wish him all the best in his new career. Now, when I was asked to speak here today, it was suggested that I might talk about what's new in the Court of Appeal in employment law. And the answer in most years would be not too much. We don't see many employment law cases, largely because most of those that do go to trial turn on the findings of fact at trial. And as you know, those are difficult to appeal. Happily this year, for me at least, there were two cases that are of some significance. Neither case says anything that's new or revolutionary in employment law, but I think both of them add clarity to some of the important issues that when you're practicing employment law you will deal with on a regular basis. The first case is Prinzo and Baycrest. It's useful for two reasons. It's useful because it talks about a number of substantive issues relating to the notice period for terminating without cause, and also deals with damages for mental distress or suffering associated with the termination. It's also useful because it provides a good illustration of the types of issues on which the Court of Appeal will interfere with a trial decision and the types of issues in which it will not interfere, equally as important. It's a decision written by Justice Weiler. Some of you probably are aware of the facts. Let me very briefly hit the highlights of the facts. The employee was employed at a beauty shop at the defendant at Baycrest retirement home for 17 and a half years. 40% as a manager, and that becomes important in terms of the notice period. In November 27th, 1997, she was given a layoff notice. It said, on a date to be determined. It did not have a specific date. An issue arises, did the notice period commence on the date that she received that layoff notice? The next set of facts were critical to the issues on the appeal. The next day after getting that notice, she went off work and didn't return until February the 9th, so for about 2.5 months. The issue became, was she able to work or was she malingering to avoid the layoff? You can imagine the fight that took place at trial about that issue. But what's important from the appeal court standpoint is the trial judge made findings of fact. Trial judge found she was unable to return to work, that she wasn't malingering. There was some evidence to support that finding, and so when the case comes to the Court of Appeal, while it may have been a huge issue at trial, it's a virtually non-issue at the Court of Appeal. The Court of Appeal, if there's some evidence to support it, simply accepts she wasn't able to return to work, as the trial judge said. During the period that she was off, a nurse from her employer and her boss called her repeatedly, urging her to return to work to modified duties. She gave evidence that that created stress and that it bothered her. And the court found, again, you can imagine the dispute at trial about this. The court found, yes, it did create stress. Secondly, that her boss knew it was creating stress and discomfort. And thirdly, that even knowing that, he continued to make the calls urging her to return. Again, those findings in the Court of Appeal, because there was some evidence to support it, are simply taken as a given. The analysis proceeds from there. Also during that period in December, the boss had written a letter to her implying that her doctor said she was able to return to work, when in fact the reverse was true. The doctor had said she wasn't. Now that's the type of fact that's going to play a huge amount of importance both at trial and indeed in an indirect way in the Court of Appeal, because that type of fact really shows some bad faith, misleading, and so on. And once one begins to look at a course of conduct, when the conduct crosses over that line, it becomes a very much of an uphill struggle for the person who perpetrated that type of conduct. And indeed, I think in the outcome in both courts, they both highlighted the fact that that was an intentional, in effect, deceptive type of act by the employer. She returned to work on February the 9th, and then on March 11th was given a notice effective March 31st that was to be terminated. She left work at that time. The employer paid her for 8 months until November. She got a lesser paying job in October. Now, the trial judge found she was entitled to 18 months' notice. She had been employed for 17 and a half years, 40% as a manager. Importantly, the trial judge found that the starting point for the notice was back at the first November 27th notice on a date to be determined, and then found also that the notice period was subject to mitigation because she had found alternate employment after 7 months, albeit a lesser paying job. The trial judge also awarded $15,000 for aggravated damages for the mental suffering arising from the employer and the nurse continuously, my word, badgering her when she was off ill. Appeal comes to the Court of Appeal. There's 4 issues that I think are worth looking at. The first is the date, the effective date from which a notice of termination runs. The court set out the law that to be effective, the date of the notice, the date of the termination must be a date certain. Now, a date certain can come about by a number of ways. The easiest one is to simply put it in the notice. It's possible that the date certain could come about by discussions and other ways information could be conveyed outside the notice. But in any event, the court laid down that principle, and the Court of Appeal found that the trial judge erred, that there was not a date certain here in the November 27th notice. The first time there was a date certain was in the March 11th notice, which did spell out March 31st. And so what we have here from the Court of Appeal is a statement of the law. It's always been that, but applying it in something where there is a notice that simply says the date will be determined. And because the trial judge, the Court of Appeal found, erred in the application of law, the Court of Appeal interfered with that decision and set the notice date as the correct date, March 31st. The error in law, as the Court of Appeal saw it, was something that had affected the outcome of the case, started the notice period too early, interfered. The second issue that the case is helpful on is with respect to the appropriate length of notice. Now, the trial judge gave 18 months. The Court of Appeal cuts trial judges a lot of slack in terms of what's the reasonable length of notice. It's a discretionary decision, and as long as it's reasonable, Court of Appeal doesn't interfere. When the Court of Appeal interferes in discretionary decisions, or it's most likely to, is when the trial judge has considered an improper factor or failed to consider a proper factor. Here, the Court of Appeal said the trial judge erred because the trial judge considered the motive of the employer in terminating her and found that there was a bad faith motive in the termination. Court of Appeal said, and this is an important point, the reason that an employer terminates an employee without cause is not relevant to the length of the notice period. That was an erroneous consideration by the trial judge. Therefore, the Court of Appeal said, having done that, we interfere. Court of Appeal set about to set the right, as it saw it, the right notice period. And in doing so, looked at the usual factors, the length of employment. I won't go into those. But 2 things it did look at are important. The first it looked at was that in terms of whether or not she was a manager, she had only been a manager for 40% of the time. The rest of the time, she worked providing hairdressing services. Court of Appeal says that should discount. She shouldn't be treated as a full manager for the length of notice. That should be a discounting factor. Second point the Court of Appeal looked at, and this is interesting, was that she had some forewarning that the termination was coming. Although the November 27th notice did not constitute effective notice, nonetheless it operated to discount the length of notice period because the court reasoned she had the opportunity during that period, and she knew something was coming, to begin to look for alternate employment. The court reduced it to 12 months. Next issue, damages for mental distress. Trial judge, $15,000 for aggravated damages. Now, they didn't order a Wallace extension because of the, in my words, high-handed way the termination had come about. In this case, the trial judge found facts capable of establishing an independent cause of action, a separate cause of action from the breach of the employment contract. Here the trial judge said found as a fact, there was evidence to support the tort of intentional infliction of mental suffering. That being the case, trial judge says, I can award aggravated damages, $15,000. Court of Appeal, bound by the findings of fact, said, yes, we accept trial judge's correct, independent tort. Court of Appeal changed it and said, we will, rather than awarding aggravated damages attached to the termination under the contract, we will actually award the $15,000 for the independent tort, reasoning that the conduct in that case wasn't directly associated with the termination, it preceded it. As a practical matter, no difference, because in both cases, it was compensatory damages for the intentional infliction of mental suffering. The last issue that I'd comment on really comes as a question. In terms of mental distress, suffering from a termination, what is the difference between an award of aggravated damages on one hand and an award for a Wallace type of extension on the other hand? And I think the answer to that question is open. It seems to me that both result from what one might call high-handed type of conduct by the employer that causes stress on the employee. The two possible differences, it seemed to me, is first of all, to get aggravated damages is probably a higher threshold because one must show there's a calculation on the part of the tortfeasor, the employer, to inflict the injury. It's probably factually harder to get aggravated damages than a Wallace extension. But that said, then one says, okay, well, what's the practical difference? It's not clear that you would necessarily get more for aggravated damages than a Wallace extension, although intuitively one would say probably a court's more likely to award higher because the egregious conduct is worse. The important issue which the Court of Appeal left open in Prinzo is, though, does subsequent employment mitigate? With aggravated damage award, the answer is clearly no. Aggravated damages are compensatory damages for the mental suffering. The fact that somebody got the job during the notice period does not mitigate. With respect to a Wallace extension, it's less clear. Two theories why a Wallace extension could be ordered. One is to compensate for the mental suffering, in which event there shouldn't be mitigation. The second is for the lack of opportunity to find other employment because the person is suffering from the distress, in which event mitigation for subsequent employment would probably make sense. A question that remains open. The second case, and I'll deal with it just shortly because I have my eye on the clock, is a decision of our court that came out 2 weeks ago. Justice Rosenberg in Grismondi and the City of Toronto. And what it's important for is it spells out very clearly what is found in the other cases, preceding cases, about when a Wallace extension will be awarded, an extension of the notice of period, and when it will not. And let me just summarize what Justice Rosenberg said. He said for there to be an extension of the notice period for the Wallace type of thing, you need something akin to intent, malice, or blatant disregard to the employee. He reviewed all the authorities and came up with that list. Now, as I said earlier, in context of Prinzo, you probably have to go a bit further than that to get aggravated damages and to show that it was actually calculated to cause damage. But I must say, the line isn't entirely clear between the two. Justice Rosenberg also said in Grismaldi that the conduct could be described in some cases as being callous or insensible, or in another case of the employer playing hardball. What's important about Grismaldi is this is an example of case where there was employer conduct, which was less than perfect for sure, but which Justice Rosenberg described as being sloppy. Sloppy in the way the employee's opportunity to stay on was handled. There was a competition and so on. But it fell short, he concluded, of the tests that I outlined of showing an intent or malice or blatant disregard, and did not warrant a Wallace extension. And so that what I would suggest, somebody wrestling with that issue, if they go to Grismaldi, they will find a clear exposition of the factors in favor and the factors which would not warrant it. So those are the two cases from the Court of Appeal. I hope you enjoy the rest of the program, and thank you very much.
Thank you very much, Dennis. It is a tremendous honor for us to have you here with us to kick off today's session. And I think from the response that you heard, I gather people agree with me that not only was it an honor to have you kick things off, but it was incredibly illuminating to have you address those recent decisions. So thank you very, very much. Now we're going to move on to the special section on. For those of you who have attended in the past, you'll know that we started the special section on in response to feedback we received on the Gray questionnaire after the first or second year, I forget which. That's a plug to encourage you to please fill out that Gray questionnaire at the end of today's session. It was suggested to us that some topics, it would be nice, some topics merit a little bit more consideration than can be provided by a single 6 or 7 minute presentation. And so what we have done in the first hour of the 6-minute employment lawyer over these past few years is focus on one topic from 4 different perspectives in 4 15-minute presentations. And today's topic also came from a suggestion in the Gray questionnaire a year or 2 ago, and that is human rights and the workplace, a topic that all of us who practice in this area deal with, no doubt, on a daily basis. And our 4 speakers on this topic couldn't be, in my view, better choices to help us in analyzing the current issues facing workplaces from a human rights perspective. And we've tried to make sure that we have a good balance of lawyers who practice on both the employer and the employee side. Kicking things off is Yola Grant. And Yola, you'll recall, if you were here last year, was a part of the faculty last year, and I can tell you she was one of the members of the faculty who received the highest rating from registrants. She has 14 years of combined experience in policy and public law practice related to employment, labor, and equity issues. She was tribunal counsel to the Pay Equity Hearings Tribunal, the Human Rights Board of Inquiry, and the short-lived Employment Equity Tribunal. She also is a former co-chair of the National Legal Committee of LEAF. So without further ado, I'll ask Yola to come up and get us started on human rights and the workplace. Yola Grant.
Good morning, everyone. I've prepared a little bit more than 6 minutes, so I'm hoping I will indeed end on time. You have my paper, and what I'll try to do is just highlight some sections of the paper, and I'm sure I'll be reminded of the time as we go along. First, my purpose here. The presentation today, I hope, will provide you with some of the outline that we commonly associate with procedural fairness, but I want to focus especially on bias considerations as it in my view, has a lot to do with human rights, because fundamentally human rights is about eliminating bias, typically bias that results in decision-making that negatively affects disadvantaged persons or persons who belong to groups that have historically been disadvantaged. Is this better? Yes. Okay, thanks. Okay, in very general terms, human rights statutes seek to recognize the inherent dignity of each individual and to assure equality of access to the benefits derived from membership in community. All of the federal and provincial legislation seek to prohibit discrimination, and typically this is done by protection on what's called listed grounds. They're actually listed, articulated, compared to the Charter, where we have some listed grounds, but there was room left in the Charter, Section 15, for the courts through common law to develop other categories that are akin to those listed grounds. What are the requirements that are imposed on decision makers, typically to ensure fairness? I'm going to focus on procedural requirements only. We are all well aware that you can engineer systems to follow certain rules and achieve, at least at face value, a form that appears to be fair and still end up with decisions that are perverse. We know that. It can happen, and sometimes it's designed, in fact, to ensure that that happens, so as to mask other motives. I'm going to presume that as lawyers advising in the workplace that you're not going to facilitate that process, so that even as I speak of ensuring fairness, you recognize that it, of course, does not guarantee substantive fairness. That you still have to get at imaginative solutions, particularly if you're dealing with disability and the need to accommodate. But if it's not a case where you really have to be creative about finding solutions, and it's simply a matter of whether or not you're going to ensure everyone has equal access to, well-articulated requirements, job requisites, etc., so that people can be promoted fairly or hired fairly, that you will advise your clients to keep an eye on substantive matters also. Okay. In my paper, I deal with fairness principles as well as natural justice principles. Typically, public bodies are governed by either natural justice or the common law fairness principles. Human rights legislation, unlike the Charter, governs private actors as well as public actors. And it's my proposition to you that your clients would be well served if you were to advise them to mimic the common law fairness principles that apply to public actors. There is no law yet that expressly states that in ensuring or applying human rights legislation, one should adopt common law principles of fairness. But in my practice, what I've came to realize, and once I did, it didn't seem like such great insight, but I propose to share it anyways. In my practice, I came to realize that there is no case of discrimination, none whatsoever, that does not involve a breach of fairness principle. It's not terribly profound, but for me it was. And so here we are. And one of the things I do when I guide my clients, large corporate employers, around putting policies in place to address workplace needs or clients' needs, particularly in Toronto where we serve a diverse population, every day I trumpet the need for fairness principles, basically starting with notice, ensuring that people have very clear notice of what rights are at stake, what benefits are available to them, so that it's not selective who hears, who applies. Secondly, that there is a realistic opportunity to respond, so the timing is orchestrated so that maximal opportunity is given to those who are interested in receiving the benefit to come forward, and finally, that whoever is making the decision is unbiased. Now, to deal with bias, one, of course, like it or not, you get into subjective factors, whether someone is sensitive to, whether they acknowledge, the presence of racism, sexism, heterosexism, or other forms of discrimination that unfortunately infect our society, it's a difficult area as a lawyer to grapple with because it is highly subjective. But in the work that we do in human rights, particularly in the workplace, we must deal with it. It cannot be avoided because work is a very important part of most everyone's life. Those of us who are self-employed have some luxury in being our own bosses and not being subject to others' whims. But most people in society are in fact dependent on a reasonable decision-making capacity in their bosses and supervisors. I'm going to take you now to the fairness principles and get away from natural justice. You all know tribunals, statutory bodies, either in their governing legislation or through the SPPA or federal court rules governing particular tribunals, have clearly articulated ways of doing things to ensure fairness. The common law principles I've mentioned quickly were notice, opportunity to provide input, and unbiased decision-making, commonly applied to tribunals without specific statutory provisions. And as I'm proposing, it's something that you can adopt in everyday decision-making also. A focus on bias and including its subjective elements. One of the things to note is that bias is a breach both of natural justice and fairness principles. Bias is unmistakably linked to any notions we entertain of discrimination or harassment. Whatever definition you use, bias is inherent in its in how it's actualized. In the paper, I give you a definition of discrimination from the Andrews case, dealing with both direct, but more importantly with systemic discrimination. Also in the paper, I refer you to a fairly recent decision of the Supreme Court, sometimes referred to as RDS, that involved examination of judicial bias arising out of a youth court decision in Nova Scotia. In that case, the court articulated what the test is for bias and simply adopted what had been in the law, or reiterated what had been the law since 1978 in the decision of the Supreme Court in Committee for Justice and Liberty. And that definition you'll see, that test you'll see in the paper. The court made it clear for anyone who doubts it, though it often comes up in human rights issues. The test for dealing with bias is simply one that deals with reasonable apprehension of bias. There is no legal requirement and has never been any legal requirement to prove actual bias. But those who practice human rights law know that it keeps propping up, as if somehow litigants are expected to be mind readers and to extract proof out of people's thoughts. If we focus on the reasonable apprehension of bias test, you'll see that there's a reference to the reasonable person. And as all of us know in law school, that in itself begs other questions, just who is that person? Fortunately for us, though, the Supreme Court has gone on recently to articulate a little bit further who the reasonable person might be. And in RDS, it speaks to the reasonable person being someone who should be taken to be aware of the social reality that forms a background to a particular case, such as societal awareness and acknowledgement of the prevalence of racism or gender bias in a particular community. In that decision, the court was quite split. It was like a three-way split. Part of this split, there was a minority opinion by Loretta Dubé and McLaughlin. The current Chief Justice, who went on to say that reasonable person should also be a right-minded member of the community, a community which in Canada supports the fundamental principles entrenched in the Constitution by the Charter of Rights. It went on to say further that the reasonable person must be taken to be aware of the history of discrimination faced by disadvantaged groups in Canadian society, protected by the Charter's equality provisions. And quite importantly, this minority of 2 went on to say these are matters of which judicial notice can be taken. Now, this question of judicial notice is one that dogs human rights practitioners in front of tribunals, I guess you'd call it administrative notice, because it, of course, gets back to a level of proof required to establish that discrimination is a factor in decision making. The Court of Appeal in Ontario in criminal matters have had a bit more experience than most of our human rights tribunals across the country in dealing with the issue of judicial notice and racism in particular. And you'll recall the decision of the Court of Appeal in Parks in 1993 that quite boldly stated racism, in particular anti-black racism, is part of our community's psyche. A significant segment of our community holds overtly racist views. A much larger segment subconsciously operates on the basis of negative racial stereotypes, etc. Again, acknowledging it's subconscious, one cannot actually prove, so we need to be open to recognizing through circumstantial evidence and treating that as sufficient proof of the fact that some form of ism is at work. Racism, again, was before the Court of Appeal quite recently, April 16th, a decision of the Court of Appeal in the case involving Dee Brown, the basketball player who plays for the Raptors, who was stopped on the Don Valley Parkway, essentially a case of driving while black, was detained unlawfully, raised the specter that it was an unlawful stop because, in fact, he was not confronted initially with the issue of his speed, but felt that he was targeted because he was driving an expensive vehicle and the police had pulled up alongside to examine him first, ran a check. On those facts, he actually ran a check and understood that the vehicle was not stolen and had no further reason to stop the player. Here, the Court of Appeal, again, relying on Sparks, speaks of racism, but went further to state that no actual proof of intent, malice, or bad faith, essentially, on the part of the particular officer needs to be proved. That it's sufficient in a claim of racial profiling to prove that the police there is no requirement in a claim of racial profiling to prove that the police officer holds overtly discriminatory views or prove that a particular instance of police conduct fits into a wider pattern of police abuse. Again, this is a major step forward in terms of judicial notice of the operation of racism, in this case in the criminal justice system. There are a couple of examples outlined in my paper, one dealing with direct discrimination, straight up examples of screening resumes early on in the process because of presumptions about people's backgrounds or religious status, as one might disclose through surnames. And the second is a slightly different, more complex example involving and professional associations' requirement that everyone meet a certain proficiency. I'm done. Thank you.
Once again, behold the magic lemon. My apologies. It has a mind of its own, Yola. Thank you very much. The duty to accommodate. Those of you who assist employers will have no doubt heard one of your clients say, "How far do we have to go? It's not fair." Well, Frances Gallop is a partner at Fillion Wakely, and she has agreed to address that vexing question, at least vexing from an employer's perspective. She practices labor and employment, including human rights law, and is a certified specialist in labor law. Frances Gallop.
Well, thanks very much, Matt. Can everyone hear me? All right, great. Well, perhaps as Matt has pointed out, the topic itself reflects a certain amount of bias, and a certain amount of frustration that one can have acting for employers and trying to assist them in understanding the duty to accommodate and how far they actually have to go in accommodating disabled employees in the workplace. So my topic today is to explore the practical limits on the duty to accommodate and to discuss this question of what does an employer have to do and what does an employer not have to do. So very quickly, I'd just like to review how the duty to accommodate arises. As I'm sure most of you are aware, under Section 5 of the Human Rights Code, direct discrimination in employment is prohibited. An employer can't discriminate against an employee because of a handicap, and the term handicap is defined in the code in an extremely broad fashion. However, Section 17 of the code allows an employer, for example, not to hire an employee or not to have an employee in a position if the employee is unable to do the essential duties of the job. But the catch here is that an employee is not to be considered unable to do the essential duties of the job unless they can be accommodated to the point of undue hardship. The second way that the duty to accommodate can arise under the code is under Section 11. And that section prohibits essentially requirements, qualifications that may not be intended to discriminate against an employee, but have the effect of discriminating against a protected group, such as handicapped employees. However, under Section 11, if an employer can show that the qualification is reasonable and bona fide, then that qualification is permissible. But again, there's a catch here, and the catch here is that a requirement cannot be considered to be reasonable and bona fide unless it's impossible to accommodate the needs of that group without undue hardship. So that's how the duty arises. So then it raises the question, well, what is undue hardship for an employer? What is the point of undue hardship? Unfortunately, the Human Rights Code doesn't offer a lot of guidance to employers on this point. There are three factors that are listed in the code as being factors that can be considered in whether there is undue hardship. Those factors being cost, health and safety, and outside sources of funding. So there's not really a great deal of guidance there. The code also refers to standards which are enacted in regulations. This provision in the code has been in the code for, I believe, 17 years. There are no regulations on the point. So, not surprisingly, given this lack of guidance, there's been a tremendous amount of litigation between employers and employees over the duty to accommodate and whether a particular accommodation is or is not reasonable in the circumstances. And there have been lots of Supreme Court of Canada and appellate court decisions, and some of those are discussed in detail in my paper. There have also been, and this is something that you might find useful sort of from a practical point of view, there have also been a tremendous amount of labor arbitration cases where labor arbitrators have had to sort of grapple with day-to-day nitty-gritty questions about shift accommodations, changes in shifts, changes in hours of work, things like that, changes in work assignment. So if you're looking for guidance on a particular problem, you may find the LACs to be a very useful source of information on that. So I guess the next question I'd like to talk about is, where does all this leave you if you're a lawyer who acts for employers and have to advise employers on what they must do and what they're not obliged to do, or if you act for employees and you're trying to assist your client in terms of helping them understand what they can expect their employer to do and what is not reasonable. Obviously, each situation has to be assessed based on its own merits and its own facts, and that case-by-case kind of determination is very, very important in when you're dealing with any kind of human rights issue. But I'd like to just offer you some general guidelines. First, 6 things that I think an employer should do based on the case laws that's developed. And then I'm going to share with you 6 things that I think an employer is generally not required to do. So here's my list. Number 1, points that an employer must do. Employers will have to experience some hardship in accommodating an employee. The term undue hardship, as the Supreme Court of Canada has suggested, would suggest that an employer may have to experience some cost, some inconvenience in accommodating an employee. Second point that's very clear is that larger employers with greater resources at their disposal will be expected to do more than smaller employers. Although I would just also note that sometimes I've been surprised at this, but sometimes you have smaller employers who perhaps are partly or entirely funded by government ministries and so on. And I've been surprised because sometimes employers who have that kind of funding actually have been able to secure funding to assist them in accommodating an employee. So be alert to that possibility. The third point is that employers should consider all available options and look for alternative approaches to accommodate an employee, the approaches that don't have the effect of discriminating against an employee. And it may be, I'm not suggesting that just because something's a theoretical, possible approach that an employer necessarily has to follow that approach, but I think an employer should be prepared to show that at least it's considered the possible options, and if it's rejected a particular option, then it should be prepared to show why. Employers should be proactive in the accommodation process. For example, if an employee indicates that they're able to return to work from an illness, an employer shouldn't just sit back and say, well, we'll wait for the next vacancy. Employer has to take active steps to get the employer back into the workplace. Number 5, the obligation is ongoing. An employer should be reconsidering the accommodation as circumstances change. So for example, an employee may become more disabled, they may become less disabled. Opportunities might arise in the workplace that weren't there initially. So the employer should be keeping an eye on those things and make adjustments as are necessary. And finally, I think it's pretty clear that an employer may be required to make modifications to a position to accommodate an existing employee. For example, there may be some duties associated with a position that are not critical, not essential to performing the position. Employers are required, I believe, to be flexible and make adjustments in the position as required. So what are the limits? And this is probably the part of the presentation that some of you are most interested in. Number one, I think it's becoming fairly clear that an employer isn't obliged to create unnecessary work just to keep a disabled employee occupied. And I don't think that an employer has to maintain an employee indefinitely in a position that's not productive or doesn't add any value to the employer. Secondly, an employer is not required to continue to employ an employee who hasn't been able to come to work and isn't going to be able to come to work. Now, this may seem like a ridiculously obvious thing to say, but it actually hasn't been obvious. There's been litigation about that both in the courts and I had a case in front of a labor arbitration board where that very point was an issue. And I think that, that I can confidently say that if an employee hasn't been able to come to work and they can't come to work in the future, it's not prohibited under the code to terminate the employee. The third point, and this is very important to know for those of you who act for employers, an employer is not required to continue to try and accommodate an employee who is not cooperating in the process. And while, you know, many employees, probably most employees, are very cooperative and very willing to participate in the process, there are some employees, and there is definitely in some sectors, there's a mentality that all the onus is on the employer, and the employee can just sit back and expect the employer to look around, and the employee doesn't really have to do anything. The employee doesn't have to provide information. The employee doesn't have to work with the employer. That's not the case. Thanks, Matt. Three final points quickly. An employer is not, this point sort of relates to the previous one, an employer is not required to accommodate an employee who is not providing sufficient information for the employer to make the accommodation. The fifth point is an employee cannot expect perfection, and they are not necessarily entitled to have the particular accommodation of their choosing. And finally, an employer is not required to accommodate an employee where doing so would jeopardize their health and safety or the health and safety of others in the workplace. So just to conclude then, the duty to accommodate is significant, but there are limits on it. These are discussed in more detail in my paper, and I guess like Yola, I'm done. Thanks very much.
Admit it, the first question you ask yourself when you receive a human rights complaint on behalf of an employer is, can I bounce this under Section 34? Well, Allison Taylor is going to help us answer that question. She practices primarily in the area of employment law with a great deal of specialty and expertise in the area of human rights. She's counsel and has been since 1996 at Stringer Brisbane Humphrey, and she's co-author of the Corporate Counsel Guide to Employment Law.
Thank you, Matt. Good morning. Unfortunately, in this topic, as in many topics, the answer to the question is, it depends. And I'm sure you're amazingly surprised to hear that. I'm going to tell you about several cases this morning that deal with Section 34 to show you the kinds of pitfalls that can arise as to when you can and cannot get a complaint bounced at the outset under Section 34. Section 34(1) of the code reads, where it appears to the Commission that A, the complaint is one that could or should be more appropriately dealt with under an act other than this act, B is the subject matter of the complaint is trivial, frivolous, vexatious, or made in bad faith. C, the complaint is not within the jurisdiction of the Commission, or D, the facts upon which the complaint is based occurred more than 6 months before the complaint was filed, unless the Commission is satisfied that the delay was incurred in good faith and no substantial prejudice will result to any person affected by the delay. The Commission may, in its discretion, decide not to deal with the complaint. So this is a discretionary power that resides with the commissioners. Section 34 applications, if you want to put it that way, can be brought at any stage of the proceeding, but typically, of course, they're brought at the intake stage in the hope that you don't have to go through the agony of the rest of the proceeding. And typically they're brought by respondents, although technically the commission staff themselves can raise the issue, the commissioners can raise the issue, and even the issue can be raised by a board of inquiry. The decision is, however, made by the commissioners themselves. Now, there's also a provision in Section 37 that allows the decision under Section 34 to be reconsidered at the initiative of the complainant. That is, if the case is bounced, the complainant can seek reconsideration. I want to deal with 3 cases that deal with A, B, and D of Section 34(1). The first one deals with the question of whether a complaint could or should be more appropriately dealt with under an act other than this act. I think you'll see that linguistically that section is not very well written. Should be more appropriately dealt with is not really grammatically very appropriate. One would have thought it would be could be more appropriately dealt with or should be dealt with elsewhere and not with appropriately involved. But in any event, it's one of many linguistic problems, I think, with the Act. In any event, the case I want to talk about is Thomas and Ontario Human Rights Commission, a decision of the Court of Appeal from 2000. This was a case in which the employee, a woman, was employed by Midas for about 21 years. It was a very male-dominated workforce. There were 3 women and 172 men. She worked as a machine operator, amongst other things. She was terminated for cause after a workplace altercation in which she was alleged to have verbally harassed and threatened a co-worker who happened to be a union steward. And there were a lot of bad feelings between these parties. She did not originally allege sexual harassment by this individual at the outset, but that ultimately became the issue. She was a unionized employee. The union agreement had a provision that did incorporated the terms of the Human Rights Code. Of course, the Labor Relations Act also incorporates those terms. So technically speaking, her issue could have been raised before the arbitrator in connection with the termination. She did make a complaint about this conflict of interest on the part of the steward because of this harassment. This was internally investigated by the union, and its human rights specialist concluded that the workplace wasn't really comfortable for women, and there'd been a lot of conflict between this woman and the steward, but that the harassment was not sexual in nature. The arbitration went for 5 days, and ultimately the arbitrator dismissed the termination grievance and said, yes, Midas had just cause for the dismissal. The arbitrator very briefly touched on the complaint of harassment and the fact that it had been investigated by the union internally, and concluded from that union report that there was no evidence of any sexual harassment by the union steward. The complainant filed her complaint with the commission against Midas after the arbitration hearing had begun. And it is made reference to in the arbitration decision, and in it, of course, she claims that she was denied equal treatment because of her sex and because of sexual harassment. The commission rendered its decision sometime later after the arbitration decision had been concluded, and it decided under Section 34 of the Code not to deal with the complaint because it could more appropriately have been dealt with under the Labor Relations Act and under the collective agreement. Reconsideration was sought under Section 37. The Commission upheld its decision and said it is the Act, and I'm quoting here, and not its application in a particular case which the Commission looks to in making its original decision. And that, of course, was where the Commission ran afoul of the Divisional Court. The matter was judicially reviewed, and the decision the Divisional Court supported that decision, but the Court of Appeal reversed and indicated that the suggestion that the Labor Relations Act was available was simply unsupportable in the context of this particular case, and that one could not just look at the Act, but had to look at the particular circumstances. The court pointed out that a review of the decision of the arbitrator revealed that he didn't deal with the issues of harassment and discrimination in any significant, to any significant extent, simply noted the decision rendered by the union steward in terms of the internal investigation, and recognized that complaints had been made, including to the Commission, but didn't make a substantive decision on that subject. The court concluded that when you make a decision, when the commissioners make a decision under Section 34(1)A, they must look at the particular complaint, not at the complaint mechanism in general. So it's not sufficient to say this is a unionized employee, the collective agreement incorporates the Human Rights Code, so off you go to arbitration. That simply is not the law. The court held that the issue of appropriateness can only be determined on a case-by-case basis, and that the mere existence of the Labor Relations Act is not determinative of the issue of whether to exercise discretion or not. So the fact that the issues had been peripherally raised, and because there had been some peripheral raising of the decision of the issue of sexual harassment before the arbitrator, did not make any difference to the fact that the substance had not been examined, and therefore the Court of Appeal was of the view that Section 34(1)A had been inappropriately applied by the Commission. With respect to Section 37, the reconsideration powers, the court also criticized the decision not to reconsider on the basis that it was not a question of whether there were any new facts, that Section 37 does not require there to be new facts for reconsideration to proceed, and consequently that provision had been misconstrued as well. So in the conclusion, the Court of Appeal set aside the majority decision of the Divisional Court and referred the matter back to the Commission for a proper consideration, as it put it, of the complaint under Section 34(1) of the Act, of the Code. So essentially what this stands for is the proposition that it is just not sufficient to say, well, it's a workers' compensation matter or it's a labor relations matter, and therefore will automatically succeed under Section 34(1)A. The reality is that it's going to be a case-by-case analysis in any particular circumstance, and consequently, if your preference is to make sure that the matter is dealt with in the course of the arbitration, it's a good idea to see if you can get the issue raised there, because at the end of the day, if it's raised peripherally, you're simply not going to be in a situation where you're insulated from a complaint under the Human Rights Code. The second case I want to talk to you about is the dismal Pritchard case. Dismal in the sense that it's the never-ending story. This is a case which is still ongoing and commenced an awfully long time ago. The dismissal of this particular employee who was employed by Sears took place in 1996, and the matter is still ongoing. And so I'd like to tell you a little bit about that. This is a case that deals with the issue of what do you do when you have a release. This employee had been offered 2 weeks more than her employment standards amounts in exchange for signing a release in connection with her termination. She was told by employment standards that the release would not be binding. She sought a lawyer who said, I can't evaluate human rights issues in the time I'm given, get an extension. Sears only gave her a 4-day extension, and ultimately she signed the release and then filed a human rights complaint. It was bounced by the Commission under Section 34(1)B on the basis that primarily that the release was, the fact that she'd signed this release and got additional consideration was evidence of bad faith on her part. And at the end of the day, the reconsideration again went against her. The Commission ultimately, once this matter was brought to judicial review, the Commission flip-flopped, and there's been a real history of flip-flopping in this particular case. But I really just want to deal with the situation of bad faith. The court in this case concluded that simply signing a release is not prima facie evidence of bad faith. One has to look at whether the situation really connotes moral blameworthiness, which is what bad faith essentially means, that the Commission had improperly fettered its discretion by assuming that the minute there was a release, that there was bad faith. There was really more to it than that, but essentially that was the view that the Commission took. And that ultimately what has to look at was the consideration fair? Did the employee have independent legal advice? Was the employee suffering from some form of duress and so on, which would vitiate the release and allow the employee to proceed notwithstanding that the release had been filed or had been signed. And so in this particular case, the application of the employee for judicial review was allowed, and the matter was referred back to a determination. Not surprisingly, 2 years later, in 2001, the determination was made yet again by the Commission that it was going to bounce the complaint based on the release. Somewhat fuller reasons, but at the end of the day, the court noted that the decision was strikingly similar to the original decision. In this case, it was noted then that she had had independent legal advice, that she'd signed the release, received additional consideration, and that there was no non-economic duress. The lady involved wanted to get a copy of the legal opinion that the Commission had relied on, went back to the divisional court with respect to that issue, and ultimately ended up in the Court of Appeal, which held that she could not get that legal opinion because it was privileged. So where this case now goes is anyone's guess, but nonetheless, this case stands for the proposition that a mere release is not going to get you out of a human rights code, depending on the circumstances. The last case I want to tell you about is Gismondi, and this is a delay case. This gentleman delayed 3 months past the 6-month deadline in filing his human rights complaint. He was bounced on that basis. And reconsideration also resulted in no change to that. He complained that there were insufficient reasons provided, and the divisional court again held that the reasons, while brief, were not insufficient. It did not want to dictate to the Commission what kind of reasons it should provide. And the record, it said, gave it ample evidence to conclude that he had ample notice of the 6-month period, that the fact that the complainant had the agreement of the employer that it would allow him a reasonable delay in filing, but not forever, was not binding on the Commission, and in any event, the 3-month delay was too long, and ultimately concluded that the court should not intervene in the exercise of a discretion, even if it would have obviously exercised the discretion differently, provided that the Commission had operated on proper criteria. And so in those circumstances, that delay did justify not proceeding with the complaint, and I've just made it in time. And those are my comments. Thank you very much.
Allison asked the question, where is Pritchard going next? I guess we could ask our next speaker, Geri Sanson, who had something to do with the Pritchard case. Geri is a partner at Sanson & Hart, which I always thought sounded a bit like a TV show from the 70s, I must admit. which is a law firm dedicated to human rights, labor, and employment law, as well as investigation and all of the related procedures that go along with harassment and discrimination complaints. Geri is an adjunct professor at Osgood, teaching in discrimination and the law. And most impressively, she is a recent recipient of the Law Society Medal for her work in the area of equality rights. Geri Sanson.
Thank you. Good morning. Human rights tribunals grant very broad powers to redress. Am I done already, Matt? It's rigged.
That was embarrassing.
Very broad powers to remedy complaints of discrimination. They can basically direct the party to do anything, not only to remedy the complaint itself, but to prevent further discrimination in the future. So very, very broad. In looking at the case law, there are sort of three main principles that remedies seek to do. The first is to restore the individual to the place that they should have or ought to have been if the discrimination had not occurred. Secondly, to eradicate or remove the source of discrimination. And thirdly, to prevent future discrimination. I think historically the employment bar has sort of paid only nominal attention to human rights remedies. And this goes for counsel on both sides of the employment law fence. I think typically what we would see is on the employer side, counsel wanting to make sure that you got that release for the human rights complaint as well when you were settling the wrongful dismissal, and maybe throw in $3,000 to $5,000, the little extra something for the human rights complaint. Typically on the employee side, we saw lots of cases where the individual ended up in our office because either the human rights complaint had not been dealt with or the employment law counsel had sent thinking once again only nominal damages. I'll proceed with the wrongful and you just go off and deal with that complaint on your own. Thankfully, over the past few years, I think we've seen much greater attention paid to human rights as well as the remedies. And as a result, what I think has happened is that we've seen a much greater development in the area of human rights remedies. And indeed, what we have seen in some cases is that the remedies available for the human rights complaint are much better and broader and potentially monetary-wise can be much greater than in a wrongful dismissal claim. Couple of preliminary messages. The first is, as part of any initial assessment, when your client comes through the door, you need to determine then, right there and then, whether or not there's a potential human rights claim. Lots of clients will not tell you that. They may not tell you until you're out of time. You need to ask those detailed questions to determine whether there is a potential claim, and if so, what are the kinds of remedies you're looking at. Secondly, you need to keep your eye on that settlement clock. If the negotiations break down, you've only got 6 months in the provincial jurisdiction, 12 months in the federal to get your claim preserved. I think as employment law counsel, we think, gee, great, we've got lots of time to file that wrongful, and then suddenly we're facing limitation periods while we're merrily on our way trying to resolve this. So here's the crash course. And when I say crash course, this topic is how far can and will human rights decision makers go. So I'm trying to highlight how far they have gone. I think it's helpful to know not only when assessing potential liability, but also the source of remedy for your client if you're representing the employee. The legislative provisions for the provincial statute are Section 41 for the Ontario Code and Section 3 for the Canadian Human Rights Act. Dealing first with monetary remedies, special damages. Back in 1989, the Ontario Court of Appeal said they're supposed to put the person back into the place that they would have been if the discrimination had not occurred. Took a while for that to sink in the context of what that meant, but what it meant is it's not reasonable notice period. And the best example of that is the case of Alan McKee. That was a case of age discrimination. He was dismissed. Board found that age was the reason. He was actually one of 3, but the only person who proceeded with a human rights complaint. He got 8 years lost wages, as opposed to perhaps 12 to 24 months, which he would have gotten in the wrongful. Imagine now what his damages might be if the government seeks to remove the cap on the 65 years. The other case I think that's worthy of note is that it's on some levels irrelevant as to the duration of the actual employment in terms of that remedy. And in the case of Hom and Impact Interiors, sexual harassment claimant who only worked a couple of days and then quit as a result of the sexual harassment, got damages until she started the new job. That was varied by the divisional court, ultimately successful at the Court of Appeal. Lost employment-related benefits, yes, things like long-term disability, weekly indemnity, those kinds of things you expect the replacement value in either negotiating settlements or if you're proceeding. The one case of note is Joadin, and in that case, the board, the claimant who was dismissed was about to go off on pregnancy leave. She was 1 week shy of being eligible to collect those benefits. The board ordered that the employer pay the entire replacement benefit, so the entire pregnancy benefit that she would have gotten under EI. Out-of-pocket expenses, job search, yes. Relocation expenses, yes. Also reasonable medical expenses, including cost of future care. The next section is general damages, and this is the area in which we have seen the most growth. And we've seen the most growth for 2 reasons. The first is a remarkable decision by the divisional court in Shelter Corporation. And the divisional court, for the first time, made clear that there is no cap on general damages. And that is like big news in the human rights world. Traditionally, boards have awarded damages, general damages under 2 heads. For the loss of dignity and the infringement of the right itself as one head, and then as a separate head under mental anguish. Under the statute, there is a statutory cap for mental anguish at 10 grand. So what was happening is that boards were interpreting the first head of general damages as there being a statutory cap on that as well. But the divisional court has now made clear no cap on the general damages. And I would suggest that this is huge in the sense that, number one, it's for the intrinsic loss of the right itself, and number 2, you don't get into all of the hoops of the legal tests, which is set out for the mental distress claims that you get into under the separate head. Just to highlight some of the recent awards, I think the highest general damage award we've seen to date is in the curling decision, and that's at $41,000. In Kiatola and Value Propane, and all these cases are noted for you in our paper. The board awarded a total of 40 grand, and a lot of these decisions have multiple awards, and so the boards, as a way of getting around this, what they presume to be a statutory cap, were pumping up the total damage awards by saying 10,000 for this infringement, 10,000 for that infringement, 10,000 for generals, 10,000 for mental anguish. So we've seen a stark move. There are now a number of decisions that are in the $20,000 to $30,000 to $40,000 range on the general damages. One of the big benefits of general damages is that there is no tax on those general damages. And we've referred to the IT bulletin that talks about the ability to allocate a reasonable amount of any settlement as general damages. And I guess what's reasonable depends on the developing case law. We now have shelter, so I think that's moved somewhat. Just as a couple of examples, the ODSP has a cap of $100,000 for general damages. The Ontario Works Act has amounts up to $25,000. So just to give you a really brief math example, if you're negotiating a settlement, it makes a lot more sense if you can negotiate that amount for generals as opposed to lost income. Example of 21 grand. You've got income subject to withholding tax of 7 grand, 30%. Employee only gets 14 and likely has to pay more tax at the end of the year. If you instead have a settlement for 17 grand and it's all characterized as generals, not saying that I would ever do that, then the employer only pays 17 and the employee gets 17, and guess what? Everybody's happy. You need to say the magic words in your settlement claim. It needs to say $17,000 as general damages for any claims under the Human Rights Code. You need to say that for the tax person, and you need to say that for any EI potential clawback. Under the federal code for generals and mental anguish, there are statutory caps of 20 for each. I've done a whole section on systemic remedies, some very important pieces, particularly if you're going to have your client return to the workplace, which is a remedy. We've seen remedies of reinstatement, remedies of promotion, remedies in the McKinnon case of promoting the spouse, where the board determined that reprisal, part of the reprisal was harassment of the spouse in the same workplace, even though the spouse had not made a separate claim. Legal expenses is probably the last one that I'm going to get to. While statutorily, there is no ability, if you proceed to a board of inquiry, to get your legals ordered if you act for the claimant. It's only for respondents, and then there's a high threshold of meeting that test to get costs. In practice, most of us settle our claims, and you always include legals, and that's because there's generally a companion wrongful. So I guess what I want to say is, at the commission stage, if you get to mediation, you'll often hear frontline people telling you, no, 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 no legals. And my advice is, like, ignore them. If they insist that you can't have legals in a mediated settlement, seriously, they are the frontline and often least experienced people. Ask them to either speak to their director or ask for the legal department to take a look at it, because there is no reason when an employer is asking for an all-in release which includes your wrongful, that you couldn't have legals. And as a final note, on the legals, there's also the ability to deduct that in terms of from tax, and they're at page 17 of our paper. It sets out the rules for that. Thank you very much.
Our hope in asking the 4 previous speakers to come together on human rights is that we would, in effect, put together the dream team on human rights in the workplace. Imagine, if you will, the human rights specialty law firm of Gallop, Grant, Sanson, and Taylor. Would that be an impressive firm? No doubt. Thank you very much to the 4 speakers. I think you'll agree with me that was an excellent introduction and detailed update on human rights issues in the workplace. Now we're going to I'm going to suggest a 10-minute as opposed to 15-minute break to try and catch up. And then Randy, I should say, Yaana, Mr. Justice Echlin will bring us all back together. Hi, how are you? Yes, good to see you again.
Good to see you too. Good to be here.